Practice before the IRS is broader than most people think. It covers matters connected with a presentation to the IRS or anything tied to a taxpayer's rights, privileges, or liabilities under IRS-administered law. On the EA exam, they'll test whether an activity is IRS practice even when you never step into an IRS office. Think, interacting with the IRS system on the taxpayer's behalf. So what activities count? 4 big buckets show up in Publication 947. 1. Corresponding and communicating with the IRS. Calls, letters, online account messages. 2. Representing a taxpayer at conferences, hearings, or meetings. 3. Preparing and filing documents with the IRS, like responses and requests. 4. Giving written advice that could be used for tax avoidance or evasion. That last one surprises people, so expect it on questions. Power of attorney is the common tell that you're in practice territory. Form 2848 authorizes you to act and speak for the taxpayer with the IRS. Example, a CPA calls the IRS to set up an installment agreement for a client who doesn't want to talk directly. That phone call is practice before the IRS because it's representation and communication about the client's tax liability. Now the what doesn't count list. First, representing taxpayers in U.S. tax court is not practice before the IRS. Tax court has its own admission rules. Second, merely being a witness isn't practice. A witness can provide facts but can't advocate. Third, just preparing a tax return by itself is not practice before the IRS. The exam loves that trap. Return prep alone isn't representation. Return preparers are where questions get tricky. An unenrolled preparer generally cannot represent a taxpayer in an audit just because they prepared the return, but there are limited representation situations. For example, a preparer with a current AFSP record of completion can represent a taxpayer during an exam of a return they prepared. The key exam cue is, do they have the credential that grants limited practice, and is it their own prepared return? Publication 947 also recognizes limited practice based on relationship. An employee can sometimes represent their employer on payroll tax matters. A fiduciary, like an executor, can represent an estate, and in certain cases, a family member can represent a relative. On the EA exam, watch for the reason they're allowed in. It's not because they're helpful, it's because the relationship creates limited authority to act before the IRS. Finally, not everyone can practice even with a power of attorney. Only individuals can practice. Entities like corporations and partnerships can't. And if an individual has lost eligibility, the IRS won't recognize them as a representative, even if they're named on a POO. Think suspension or disbarment by OPR, inactive retirement status, or failing renewal requirements like continuing education. On exam questions, they have a POA doesn't override, they're ineligible. Marcus was audited and the IRS disallowed a large business deduction. He took the case to U.S. tax court and won. He hired a lawyer to file the petition and paid court filing fees. Can Marcus recover the legal expenses he incurred to defend his position? The choices range from yes, but only if certain requirements are met, to no reimbursement at all. Think about it. The best answer is yes, but only if the statutory requirements are met. A prevailing taxpayer may be awarded reasonable administrative and litigation costs, including attorney's fees and court costs when they qualify, especially if the government's position wasn't substantially justified and other limits are satisfied. The tempting wrong choice is no reimbursement, because people assume each side always pays its own way, but tax law allows cost recovery in qualifying cases. A case in the U.S. tax court is commenced by what action? The options include an IRS impasse, a formal protest, the filing of a petition, or a taxpayer's appeal. This is a classic procedure question. Think about it. The correct answer is the filing of a petition. A tax court case starts when the taxpayer files a petition with the court, generally after receiving a statutory notice like a notice of deficiency, and it has to be filed within the deadline. A formal protest and an appeal are IRS administrative steps, not what opens a tax court case.